This video is going to talk about our third way that damages could be limited. Mitigation is one of the three concepts that we're going to learn under avoidable consequences. But before we get into the cases, I want to give you the big picture rule. If a plaintiff could have reduced the size of a loss by reasonable conduct, the court will not compel a defendant to pay for those avoidable losses. However, a plaintiff can always recover for any expenses reasonably incurred in an effort to avoid further loss. This is considered incidental damages. So whatever damages are incurred from trying to mitigate, they'll still be able to recover from that. Our first case deals with contracts under the UCC, which is goods. And in this case, what happened between Groves and Warner? Well, Groves was awarded a subcontract to build a bridge's concrete decks, and Groves contracted with Warner to deliver the concrete to the work site. But Warner was lagging, so Groves was considering alternative sources. It was too expensive for Groves to do it on his own by building its own batching plant at the site, and the only other source of ready-mix concrete in the area was Trap Rock Company. Groves didn't opt to use Trap Rock Company because Trap Rock Company was not certified to do the work in the state. The price was higher, Trap Rock Company had limited number of trucks, and Warner assured Groves it would improve its deliveries. However, it didn't improve. And on June 21st, the Pennsylvania Department of Transportation decided to stop the construction of the bridge until Warner's performance could be discussed. Eventually, they decided to resume, and between June 26th to July 20th, Warner did significantly improve, but it was still unpredictable. During that time on July 11th, TRC became certified in the state and agreed to accept the same price as Warner, but at that time, Groves decided to continue with Warner instead of asking TRC to be the supplemental supplier or replace Warner. What is the issue in this case? There are actually two issues. One, was Groves required to mitigate damages by hiring TRC to deliver the concrete? And two, does the duty to mitigate apply when both parties have an equal opportunity to mitigate damages? Before we go over what the appellate court decided, let's review what the trial court held. And here, the trial court held that Groves had no reasonable expectation that W would perform because W had been acting in bad faith by overcommitting and not performing by continually delaying, which meant that Groves had an obligation to utilize TRC to mitigate W's delay. Thus, Groves cannot collect for any losses after July 12th, which was the day that TRC agreed to match Warner's price, and it had already been certified to do business in the state on July 11th. Now, the appellate court completely disagreed with the trial court. It held that Groves actually had no requirement to mitigate damages by hiring TRC because staying with Warner was completely reasonable. The appellate court also said that there was no duty to mitigate when both Warner and Garner had the equal opportunity to mitigate the damages because the burden should be on the party breaching the contract in bad faith. Now, what were the explicit rules the court used to determine its holding? The court said the requirement to cover or mitigate damages is not absolute, but subject to circumstances. The circumstances were specifically the test of proper cover is whether at the time and place, the buyer acted in good faith and in a reasonable manner. It becomes immaterial whether the method the buyer used to cover was not the cheapest or most effective if you analyze it later on. And so here the trial court determined that Groves acted unreasonably because Warner continued to delay and they could have saved money by going with Trap Rock Company. But the appellate court said at the time when Groves made the decision, it did act reasonably because both hiring TRC or continuing with W were reasonable courses of action. Because TRC actually received some of its raw materials from Warner, and Warner might not cooperate with TRC if Warner knew that TRC was taking its business away from Groves. Also, even if TRC acted as a supplemental supplier, Warner might still fail to perform, which means that there would still be damages suffered and the project would be delayed. As to the second issue, the rule is if both parties have an equal opportunity to reduce damages by the same act, it is equally reasonable to expect the defendant to mitigate damages. The plaintiff's duty to mitigate is not applicable. So the second issue the court dealt with pretty much created an exception for the duty to mitigate. So usually the plaintiff does have a duty to mitigate, but not when there's an equal opportunity for the defendant to also do the same thing to mitigate the damages. Because the court said the burden is on the breaching party who put the non-breaching party in this situation. So the burden was on Warner to actually hire TRC to help it make its deliveries on time, rather than putting the burden on Groves to hire TRC to make sure the deliveries came in on time. Now let's go back to our big picture rule. Where does this case fit in? Well, the first rule, which is the test is whether at the time and place the party acted in good faith and in a reasonable manner, is just another sub rule you can use under the UCC to determine what's considered reasonable conduct. If both parties have an equal reasonable opportunity to reduce damages, the plaintiff has no duty to mitigate, the burden's on the defendant. This is an exception. If the plaintiff doesn't mitigate, the plaintiff can still recover the full damages if the defendant could have equally mitigated the damages. Now let's go to our second case. And now we're in contracts, common law. So we're not dealing with goods, we're dealing with an employment contract. And in this case, we had Shirley MacLaine, a well-known actress who was cast as a female lead for Bloomer Girl, which was supposed to be a musical production to be filmed in California. The defendant, 20th Century Fox, offered her the female lead in this movie called Big Country, which was different. It was a dramatic Western movie that was supposed to be produced in Australia. However, the employment contracts were identical in compensation, and 31 of the 34 numbered provisions were the same. But MacLaine decided to turn down the role and sued for breach of contract to recover the agreed upon compensation under the Bloomer Girl contract. So she wanted her $750K. Now, what is the issue addressed by the court here? The court had to determine whether MacLaine was required to mitigate damages by accepting this Big Country role, which had the same compensation and pretty much the same contract. The court determined no, because Big Country and Bloomer Girl are different roles. And its analysis turned on whether it was reasonable to expect the plaintiff to perform in Big Country when she was originally contracted for Bloomer Girl. On page 773, this is where you get the majority rule. In employment contract situations, a wrongfully discharged employee is required to mitigate damages by making a reasonable effort to accept substantially similar employment. An employee can reject inferior or different work. And this is the burden on the employer to prove that it's not substantially similar. If the employer successfully says that the employee found substantially similar employment, the employee's actual damages will be reduced by the wages the employee earned in comparable employment. Essentially saying, well, your actual damages was less because you were working elsewhere and you mitigated them, so you made them smaller. However, in this case, we had Bloomer Girl and Big Country. One was a musical, one was a Western drama. One was in California and one was in Australia, a completely different country. Our plaintiff was an actress and a dancer, and the entertainment scene was more popular in LA. So expecting her to go to a Western drama instead of a musical, those are two very different things. And to ask her to move to another country, well, that's not the same as filming in California. And so the plaintiff received her full $750K plus the interest. Now, we had a dissent in this case where the dissent didn't agree with the majority's decision to give her the $750K. The dissent said the issue of substantial similarity to her former employment should have actually been determined by the jury and not the trial court. And so what was the rule that the dissent used to make this decision, and how is it different from the majority rule? The dissent rule said a plaintiff is not required to seek or accept any and all types of work. Only work which is in the same field and which is of the same quality need be accepted. So it's the same as the majority because it says you're not required to accept all types of work, but the type of work you're supposed to accept, this is where it differs from the majority. Substantial similarity is a little bit more broad here under the dissent rule. And the reasoning was, well, they don't want the employee to remain idle. You must make reasonable efforts to secure employment. And so even though we had a musical versus drama, California, Australia, they're still both films in the entertainment industry. And she's still the leading female, the star. So the employment type is technically the same. She should have been required to accept the contract to mitigate it. Now, where does this fit in our chart? Well, it gives us one other specific rule that we can use to determine whether the plaintiff was required to mitigate. And so the rule is, under common law employment contracts, a wrongfully discharged employee is required to mitigate damages by making a reasonable effort to accept substantially similar employment. An employee can reject inferior or different work. Now, our last case deals with the underlying cause of action of torts. And what happened here? Well, Collins contracted to lease video poker machines to two bingo hall operations, and its lease was a 6-year lease that required any purchaser of the premises to assume the lease. In 1997, when American purchased assets to the bingo parlors, it removed all the machines from the premises. so it didn't honor the lease or assume it. Collins placed 19 of the 20 machines removed from these parlors into other premises and received rent for these machines despite American's breach. So Collins, even though it mitigated, it still sued, and the court found American liable for intentional interference of contract, which is a tort. The court awarded actual damages of 157K plus and punitive damages of 1.5 plus million. And it did not subtract the rent that Collins received for putting these machines in other parlors. The Court of Appeals affirmed. So what are the issues now addressed by the court? Well, the first issue is, does the duty to mitigate damages apply to a loss volume seller? And two, is Collins a loss volume seller in this case? And the court determined, well, yes, this duty to mitigate applies pretty much to everyone in contracts and torts. And what was the reasoning the court gave for a loss volume seller not being able to mitigate damages through resale? Well, it's on page 783. If the injured party could have had the benefit of both the subsequent contract and the breach contract, then the subsequent transaction is not a substitute for the broken contract. So here, even though American had broken its contract and decided not to have the video poker machines, which allowed Collins to take those video poker machines and put them elsewhere and make rent, because Collins could have put the video poker machines in American's premises as well as elsewhere, the substitution of putting it elsewhere is not going to mitigate the damages. American is still going to be fully liable for breaching the contract because it still took away one of Collins's sales. But this rule will only apply if Collins is determined to be a loss volume seller. And here the court determined, yes, Collins is a loss volume seller. It defined a loss volume seller as one whose willingness and ability to supply is, as a practical matter, unlimited in comparison to the demand for the product. This loss volume seller theory allows the recovery of lost profits despite resale of the services that were subject to the terminated contract. So basically, you can get lost profits even if you do resale and mitigate your damages if you can prove that you had this unlimited supply compared to the demand. But you have to prove that you could have entered both transactions but for the breach, right? So you would have been able to make this extra transaction as well as performed under the contract that was breached. To summarize, a loss volume seller needs one, excess inventory, and two, be able to prove with reasonable certainty that it could have made both transactions. And in this case, they determined Collins did. Specifically, the court's reasoning, which is the application of the facts, replied to American's three arguments. American said, one, the loss volume seller rule eliminates a seller's duty to mitigate damages. Two, Collins is not a loss volume seller. And three, Collins didn't have the specific type of machines available in its warehouse. The court disagreed with all three arguments because it said the legislature approved the loss volume seller rule, which implied that loss volume sellers can't mitigate through resale. Collins actually had a surplus of machines on hand, and it was prepared to perform it if the demand increased because it had many machines at its warehouse. And even though the specific machines that American needed were at other sites, Collins had testimony that these machines could have been easily rotated from those other locations to the bingo parlors because it had so many other machines in its warehouse. For purposes of the exam, I just want you to remember there's this general rule that a plaintiff must mitigate damages if it's reasonable at the time, but they can always get incidental damages. All these other rules will give you specific rules to help you do the analysis depending on whether you're dealing with a UCC contract case or you're dealing with an employment case. And if you're not dealing with a specific contract case and it's just tort, or the contract is for something not related to goods or employment, just use the general rule that we have up here on the top in blue, which is reasonableness. As for the loss volume seller rule, even though our case was based in tort, the loss volume seller rule does tend to come up more in contract cases. And I want you to remember that a loss volume seller is someone whose willingness and ability to supply the goods at issue are unlimited compared to the demand for the product. So that's the excess inventory. Once you've determined someone is a loss volume seller, then you can state, well, the loss volume seller's resale does not mitigate damages if the loss volume seller can prove it would have entered into both the transactions but for the breach. So determining, well, if you can prove with certainty that you actually suffered this loss, then you're going to be able to recover it. And then you'd move to the third step, which we talked about in a previous video, which is determining the amount of damages with reasonable certainty.